requires any sort of intent element. It's usually somebody whose judgment is clouded because of the overconsumption of alcohol.
But Senator, wouldn't you be penalizing the vast majority of the public out there that does not drink and drive by requiring them to put an interlock device in their car?
Yes.
I'm not a liberal person at all. I am very conservative in the fact that I don't think any laws need to be passed until they are thoroughly scrutinized. And I know that opinion is shared by several of you here today. Feel good legislation, totally against it. And I have had incidents where friends of mine, I've had to set them down and say, I'm sorry, I can't support that because it infringes upon civil liberties that people had died and fought for. And anyway, I appreciate the opportunity coming today. It's not easy coming before y'all, but somebody has to. I wish that you had had more victims testify before the subcommittee, but there's nothing we can do about that.
And Mr. Randall, just know I share your desire, to eliminate drunk driving in South Carolina. I guess I'm just trying to figure out in my head, how do we get there? Because I'm just not sure if making the laws stricter or making them maybe draconian to some degree, if that is going to be the fix. So, but I certainly share your sentiments.
You've got a hard job. I must admit it. I've been around here long enough. You have to be sworn.
I just want to make one comment. Just make it short. And I know this is coming from a mom that's lost a child. But if you had any kind of concept of what that's like and how it changes your entire life, you would do anything that you could to keep anybody else from going through that hell that you live every day. And this has been going on for 27 years. And some days I can get through it, and other days it's still hard. But I'm telling you, anything that you can do, you need to do it. It's time people started thinking about what's right and do what's right. And that's it, period.
In closing, I understand you have a tough job. I would hope that you would not rush through this. Make sure that the legislation that is put forth to the House and passed into law is a good bill, a good piece of legislation. Please, in the entrance of speediness, if it takes longer to figure it out, take the time. There are good points in this bill. But anyway, that's just my opinion. Thank you,
sir. Thank you.
Appreciate it.
Before we move into section 13, there's one other person who signed up, Marquetta McCall. Marquetta, come on up, Miss McCall. If you would raise your right hand, please. Do you swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth?
I affirm.
Thank you, ma'am.
My name is Marquetta McCall, and I'm retired Army veteran of 21 years, a little over 21 years. And recently, just imagine that your house is on fire. You see no fire, you see no smoke, but you know your children and your family is in danger. The manifestation of it is coming in a respiratory issue. The manifestation of it is coming up in your hair falling out. The manifestation of it is coming up you're spitting out blood. The manifestation of it is coming when your child is waking up to a nosebleed. This is all at the hands of, it's almost like I am in a war zone in my own household, in my house, because of fighting an enemy that you cannot see, but you know that is present. And this was caused by the Army with the contract that they have with Smith Drayline. There is no regulatory guidance to give them to store our household goods in a climate controlled environment. And because of the environment that my household goods were stored, everything was contaminated with mold. And this started from me opening my boxes and having an an allergic reaction, but didn't know at the time that it was mold. I visually saw the mold on my couch, and I wish it was something that I can show the picture larger. But this was my couch that was brought in, and I saw the little spots of mold on my couch. I also have a brand new couch with the tag still on it. And with that picture there's no visual evidence of mold. This is a brand new couch, no visual evidence of mold. But I had all of my items for as what I suspected when I would break out and have these respiratory issues. And the presence of aspergillus and penicillin mold was founded on my household good items. So recently this week, it's like being in a fire and you're frozen. You don't know what to do. And I can give you a prime example in Winsboro, Louisiana, where I was raised, a family of 4 in a household fire. The daughter was up on the phone with a friend while this house is burning down. It was an elderly lady with bars on her window. And so no one knew. It's like they panicked and they couldn't call 911. So the reason why I'm giving that analogy, I'm stuck. I don't have the resources. I don't have the financial aid in order to remove everything out of my house. That we are in a war zone to protect my family health and my health from the mold of aspergillus and penicillin. It's easy to call, hey, Smith Drayline, you caused this. Could you do the right thing and remove everything out of my house? No, we're not doing that. And another point of that, I had 3 mold tests, and I allowed Smith Drayline to hire ABS Environmental. They came into my house. They fabricated the tests saying there is no mold in my house. I have an environmental specialist came out of Charlotte, and I did the investigation for us myself. What did ABS do? ABS Environmental sent my mold labs down to, I think it was Fort Lauderdale, Florida. But anyway, they sent it to Florida. I called the laboratory and spoke with him and say, hey, I would like this, because I was going to go through tape tests and send it to him. He was like, why are you calling me? You're in South Carolina. So there's so many loopholes. And not only that, this right here is a new fight for me. Trying to find an attorney to represent me. I have all the evidence to show that Smith Drayline is responsible for everything being contaminated with mold. Just this week, I also started, okay, let me start washing my laundry. Everything was still in boxes. I pull out my military uniform. Mold growth is on my jacket. My home was built by D.R. Horton, which that is another whole issue that I'm dealing with as well. And taking our right away it's a immoral, to me it's immoral, because the moral thing to do for Smith Drayline to do is to remove everything out of my house. And that's in the Bible, it's in Leviticus. If you have mold in your home, take everything out. The military have policies where that's supposed to happen. They didn't do it. They refused to do it. What I was told, their hands are tied. I wrote a letter over a month ago to Senator Joe Wilson to explain to him to try to get someone behind me to help me. No one is helping me. And with aspergillus and penicillin mold, at the worst case scenario, that is a deadly mold. And I know mold is everywhere in the environment, but it wasn't in my house until everything was brought in. The test results show when the environmentalists check the air outside, the air quality, the mold that's found in my house is not found outside. So If this law is passed, I myself, having a hard time to find an attorney, will have to petition the court myself as best of my ability, using Google, using AI, to try to do the litigation and to hold Smith Drayline accountable. And in this lawsuit, in this tort act, to me, outside looking in, it's easy to focus on the alcohol, and that's what I'm looking to see. That's what I'm looking at as what this is all about. It's about alcohol, or it's about frivolous lawsuits that's being taken place, to my understanding. To me, just focus on the alcohol part and let us that still have our rights to sue when the unfortunate happened. And in this case situation, I have to replace everything. My clothes, everything. If I call my insurance company, that's another thing that's been brought up. If I call my insurance company, yes, I pay my insurance. Guess what? My insurance is going to go up. Just by me filing, insurance goes up. And putting this tort law in place, I have been doing my research. I haven't seen now one insurance company step into the plate and said, okay, we will reduce the insurance rate if you reform your tort. Even if the insurance company say, hey, I'm going to reduce it by 10%. That's not enough, and it's not worth my rights. And a lot of South Carolina citizens, we don't know that this is going on. And I found out about 2 weeks ago, and thank God I found out about it. But this is another fight, along with me finding an attorney to represent me, to hold Smith Drayline accountable for contaminating all my household goods with mold, and putting my children and I in a war zone that we are fighting.
Any questions for Ms. McCall? Ms. McCall, thank you for your testimony.
Okay.
Thank you, ma'am. We are going to turn to section 13, and Lee Cope and Rob Mosley are here to kind of help lead us through that. Correct? Why don't we both of you come on up, and we'll do this all at one time. Make it. All right. Lee, you're still under oath. Rob, if you'll raise your right hand for me. You swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Thank you, Mr. Chairman, members of the subcommittee. I'll try to be brief. I think there's a number of things that we need to think about in the context of this bad faith revision that's being presented in this bill. First off, when I talk to my colleagues, Skage and others and people in the community, one of the questions that keeps coming up is, why is the government trying to get involved in a private contract of insurance? It's a good question, but they're only getting involved on one side of it. So we got a contract between the insured and the insurer, and this bill would say, we're going to say that the insurer gets some rights not contained within that contract, and we're going to statutorily create a built-in delay for a claim. And they say, well, what about the other side of the contract? There's nothing about this bill that protects the insured. Nothing. I don't understand. I mean, I've heard a lot of talk about fairness, and I think everybody here is working really hard to try to determine an approach that leads to fairness. But I don't understand why the government's wanting to get involved in this contract between private individuals and a private corporation. I can tell you that if you are 1 day late on a payment on your premium, there is no 3-month delay in which that you can go back and claw it back. So this 3 to 13 month time period, I don't understand. It makes 0 sense to me, 0 sense to my clients. And when we talk about insured, there's one thing to keep in mind about bad faith. It's real easy to paint me and my colleagues as the bad guys. I know there was talk about name calling. Someone shared Senator Massey a social media post where we were accused of being ISIS-like. There's really no place for that kind of conduct here, right? On either side. We're all trying to do what's best for the citizens of South Carolina, the people that I represent. But bad faith law is to protect the insured. It is not there for the claimant. So if there's a wreck and I get hurt and I file a claim against whoever caused me injury, That person has insurance and they are expecting their insurance company to step up and protect them from the claim that they owe on. That's what bad faith, the Tiger River doctrine is not targeted at the claimant, but rather the insured. The case we spoke about yesterday, the medical malpractice over in Marion County, I encourage you, and I can share with members of this subcommittee if you'd like to see it, the follow-up lawsuit that is a great discussion, a real education on what bad faith is meant to protect. In that particular case, the bad faith case is to protect the doctor who asked, who begged, who demanded that his insurance company step up and pay within the policy limits, and they refused. That doctor, according to the complaint that he filed, even offered to put $1.5 million of his own money outside of insurance to settle the claim if they would continue to negotiate within the policy limits. They refused. After the verdict, a big verdict for the death of a 16-year-old daughter, the only advice the insurance company could give him, they didn't give him any assurance that they would protect his assets. They said, you need to get asset protection advice. Okay? That is what bad faith is meant to deter, to make sure that the insured has protection with the policy that they purchased. Now, of course, this bill is going to go a different direction as well. And this is the one that hits the folks that I know the most. And that's what I would call the unintended consequences of a 13-month delay. 3 months before you file suit. If you don't agree with the valuation, another 10 months if you have to file suit. Trucking insurance companies may be asking for this bill, but the owner operators that I know that live in my community, they don't want this bill because they can't afford, if they have a property damage claim that keeps their truck off the road, 3 months bankrupts them. Absolutely. I grew up on a farm. It's a little small family watermelon farm. We had one truck. We used to drive up 321 from Hampton, come up to the old farmer's market over by where the football stadium is. If we'd had a property damage claim in June, we would be ruined by the time the 3-month period was over because you only got one window of opportunity to harvest your crop. There are so many folks in this state that need that kind of time, and a 3-month delay would be catastrophic. I would even venture to say I didn't grow up here, but obviously went to college and law school here in Columbia and ate a lot of Lizard's Thicket foods when I was in college. And they seem to be doing real well. But I would be willing to bet that if a tree fell on one of their restaurants, and in that 3-month time period, they said, we're not going to pay you yet because we don't agree with it, they would suffer greatly. But if they couldn't agree on a valuation and had to file suit, can you imagine what it would do to a business to have to wait 10 months with no recourse? Now, what we'd love to hear is, well, they wouldn't do that. Ladies and gentlemen, my experience in the last 27 years is it happens more often than you think. Now, it's real easy to understand why. It's my understanding from some reports we've seen, the internal rate of return with the inside the insurance company is 21%. 21%, which means if you've got a claim facing you and you know you're going to pay that $1 million policy, it's absolutely clear. If I can hold on to that claim by this bill for 13 months, I'm going to pay less than $800 on a thing that I know I owe $1 million on because my internal rate of return says I'm going to make all of that money up while I'm delaying this penalty, while I'm delaying this payment, and this statute would protect them from a bad faith claim. I've talked to loggers. It's terrible. I've talked to farmers. These are real folks, y'all. Whether you call them clients, whether you call them voters, or whether you call them jurors, these are the people that this will impact. Every single one of them. I understand that there are some bad actors in what I do, or at least it's perceived that way. I think I heard you mention that yesterday, Senator Massey. But the Hood versus USAA case that just came out last month is a prime example of the fix we have in place. For those of you who haven't read it, or maybe you're not a lawyer, there's some language in there that I'll tell you I have never seen in a Supreme Court opinion. And this is a case where a law firm tried to claim that the insurer did not, in a UIM case, did not step up to the plate and settle the case when they could have, and it cost them money. And the way the Supreme Court addressed the arguments was, quote, utterly meritless. We've got a safety block in place to prevent bad actors from doing bad things under the guise of bad faith litigation. And here's what the court ended on, and I think it's really relevant to what y'all are thinking about here today. And I'm going to quote this. Attorneys may have an obligation to provide zealous representation of their client, but they also have a corresponding obligation to opposing parties, the public, the courts, and others to behave in a civilized and professional manner in discharging their obligations to their client. This bill isn't necessary. We've got a Supreme Court that has stepped up to the plate and said, we're not putting up with games. This is not going to be a gotcha form of litigation. And keep in mind that the impact is real to the insured, and the unintended consequences of this bill to folks that need to make their property damage claims for their homes, for their cars. I heard someone speak earlier about if you make a claim, every friend I've got tells me they cannot believe how they get dealt with by their insurance company. If you make a homeowner's claim, they will either increase the premium so high that they get all their money back, or as soon as you make the claim, you're out. They kick you off their policy. This is what people are living every single day. This doesn't help. There are ways to address this. I would argue that our Supreme Court has shown the path forward. I think we should follow that lead, and I don't think we need to include this bill as part of the tort reform that this subcommittee is considering. Thank you.
Mr. Mosley, step on up and give us your thoughts.
Thank you, members of the committee. I would agree with some of what Mr. Cope says, and that is that it is a civility matter, and I know that the reason that it's in the bill is because it's a problem, and I'm in my office and I get an email and it's a time limited demand, and the plaintiff's lawyer has had the case for 8 months and has gotten all the medical records in and has the ability to go out and with their client's permission get their medical records and bring those medical records in, and so they have the opportunity to put all that together for 6, 8 months, 2 years, however long it is. It hits my desk and it's got a 2-week time limit on it, and it says you must pay within 2 weeks, and you have to deliver it to my office in wherever by Friday at 5 o'clock with a cashier's check, standing on your right foot and handing it to my assistant. I mean, that's a little silly, but that's the way these letters read. And if it wasn't a problem, and I know that we're punishing everybody for the sins of some, but if it wasn't a problem, this wouldn't be here, and it is a problem. Now, there's a couple of things we need to think about. Is that the insurance company and the defense lawyer needs time to address these things. When it hits my desk, the clock starts, and I've got to go do in maybe under the bill 30 days what the other lawyer had 6, 8 months to do. And so I've got to go through and figure all that out. I've got to make recommendations. I've got to get responses back. And not only that, I have a duty to talk to my clients. And I'm a trucking guy. So I generally have 2 clients. I have a truck driver who I've got to track down and try to explain to him what this means. And then I've got a trucking company that might have a little better idea what it means, but still might not be all that sophisticated to understand what's going on. And then they have the right to be heard. They have the right to tell their insurance company, we want this paid. We don't want it paid. We want you to fight. We want you to settle. And so all of that it takes time. And when I get a letter that says, you got 2 weeks, I mean, it can't be done. You can't do everything that needs to be done in that period of time. And so I certainly appreciate the bill and the need for this bill. Now, I'll say this, that, I mean, we're talking about auto insurance. We're talking about auto claims, and Mr. Cope says that we're adding to it, to a contract. Well, we already have, Title, 3877, which creates all the duties relative to the contract. So, I mean, the legislature has already decided what the contracts are going to be, and there's very little that the contract actually gets to decide, because the legislature says what the contract has to say. And so we're not changing much. Now, I'd also encourage you to remember that anytime we're talking about bad faith, we're talking about Monday morning quarterbacking. So we now know what happened, what the jury did. And so everybody's got an idea of what the jury is going to do until you actually find out. And so we've got the Monday morning quarterback bias associated already with a Monday morning quarterback bad faith claim. And so, and I'll mention one other thing Mr. Cope said about downtime on property damage claims and things like that. Well, the damages are covered, including loss of use. If somebody runs into your restaurant, or somebody runs in, to your truck and puts you out of business, well, loss of use of that truck are also covered under the policy. And so it would be, it's a silly position for an insurance company to delay when you're just running up rental car bills or rental truck bills or something like that. So the system is already set up to manage that. And so asking for 30 days, or asking for a time in which it is reasonable for you to be able to get all the information you need to fully evaluate the case seems utterly appropriate. So thank you.
Any questions? Senator from Edgefield.
You go first.
Thank you both for being here. Lee, thanks for coming back up. First off, I'll say I actually agree with a lot of what you said. And this is one of the provisions in the bill. There are a couple of them that I knew that this definitely wasn't ready to be done the way this is done, right? What I really wanted to do here was to have a conversation about the issue, because I do think, and I'll tell you this, my general preference is that we have things in statute as opposed to case law, because I think that's our job, right? It's the legislature's job to make the law. Also think it would be good to have rules in place that everybody knows what they are, as opposed to them changing depending on who's on the court. Because I think that's happened, especially in this area, some as well. Now, with that, I'll say this. All of us knows, and perhaps Rob and me more so than others, insurance companies will screw it up sometimes. Most of the time it's because you may have an overworked or inexperienced claims adjuster who just misses it. Sometimes it's going to be intentional. Both of those situations are bad. Both of those situations are unacceptable, especially if you're the claimant, you're the injured person, right? We agree on all that stuff. I think there needs to be provisions to ensure that when insurance companies do act in those manners, that there's a method of recovery. They've got to respond timely, right? 90 days is too long. If we're talking about a pre-suit status, 90 days is too long. We agree on that. I guess my question there is, what's the right time? Right? Because I do think we need to set out the rules so that everybody knows what the rules are, that even the insurance companies know what their obligations are. But what's the right time? I agree with you, 90 days is too much. 2 weeks isn't enough. Now, I also understand that if you're a claimant, 2 weeks is a long time to wait. But I think we all have to understand that realistically, whether it's you as an attorney or a claims adjuster, that's not the only case that you're working on, right? So 2 weeks is not enough time. On a pre-suit scenario, we'll get to after the suit's filed in a minute, but in a pre-suit scenario, if we're talking about time, and I'm happy to talk about what the other things are that they need to do, things like that, right? That's all. Let's talk about that. But there also should be a time limit, because they've got to respond. 90 days is too long. What's the right time?
We agree on so much, I'm tempted to leave right now because it's not usual that you and I agree this much on stuff, Senator
I
Massey.
don't know, man. I think we agree on a lot of stuff. I think a lot of the perceived disagreement is more of a narrative than reality.
Right. I don't
And
disagree.
if people would actually just talk, I think you'd find out that we do agree on a lot of stuff.
As I mentioned to you in an email, I 2 hours here and 2 hours back,
I know.
happy to talk to anybody. Let me tell you where I think I disagree with you. And the problem I see, and I'm not talking about that there's a problem with having statutes, or obviously your job is a very important job. We need it. We have to have it. Here's the problem with creating a statute that determines how long you need. You don't have any of the facts. You don't know the circumstances. I've got a picture on my phone. I wish I could show y'all. I was leaving Brunson this morning. All right. For those of y'all driving from Allendale to Hampton, you know where Brunson is. In Hurricane Helene, we didn't get much damage at all, but we got some. There is a trailer across the railroad tracks from the road to my house. There are 2 trees leaning not on it, inside the trailer. Without a doubt. I mean, you can see it from across the road. I'm happy to share my phone with you. Now, I don't know the specifics of it, but I assume if that person had homeowners policy that had wind protection, and somebody pulls up and says, yep, there was a storm, and there's 2 trees leaning inside the house, we owe the money. Now, that case, they don't need 2 weeks. Rob doesn't need 2 weeks. He drives down to Brunson. He's like, yep, there's 2 trees inside the house. It's covered. Pay the policy limits.
I don't want to interrupt you, but I want to make sure, I mean, we agree that this doesn't have anything to do with that, right?
But it does when it comes to a policy decision made by an adjuster. Am I going to pay this claim?
But it's talking about liability, underinsured motorists, and uninsured. I mean, there's been a lot of talk about homeowners claims, and I understand. I absolutely understand why people are upset with insurers. That's not what we're talking about here.
But it's the same principle. I was only using this as an example that the same type of adjuster that looks at an auto claim is going to look at going to look at a homeowner's policy. And if there's a delay, an unreasonable, unnecessary delay, how can this body, with all due respect, determine what's the appropriate time for them to take into account those facts? We do have a way to do that. And it's the bad faith laws that's been developed over the years here in South Carolina. That's not a problem. Under Rob's example, I agree with him. If he got a call that said, you got to show it with a check, hop on your right leg, be here at 3:05, wearing a purple coat, that's ridiculous. I don't support anybody that plays those games. But that's not what bad faith law allows. The few times that I've written a bad faith letter, it's always prefaced with, please let me know if you need any additional information to make your determination about whether you're going to pay this claim or not. And if that's the law.
Let me suggest to you, Mr. Cope, that your bad faith letters are not the routine letters.
But the law is the same, whether it's my letter or the outside letter. Okay, and we need to let that law, I have yet to see a problem with that law. I think the Hood case, the Skinner case at the district court, addressed those concerns that y'all are both expressing and gave very clear guidance on what is and what is not allowable. In fact, they described it as utterly meritless. That's the prevailing law right now in South Carolina.
Maybe we should codify that.
But how do you codify something that you don't know has happened yet? How do you look at the specific facts of a case and say, this is good faith and this is bad faith?
If you don't, then nobody knows what the rules are.
But we do.
And I think then we should be able to codify it.
We know what the rules are because the case law says we take it by a case basis.
But then that creates uncertainty.
We can't have certainty in everything, with all due respect, Senator Massey. I mean,
I know that, but in this area, I think we could have more certainty than we have. I mean, but I think there ought to be a time frame in which they know they have to respond, and I don't think it should be an arbitrary time limit that each attorney sets in each situation. I mean, we have to ensure that the insurers are going to respond in a timely manner. And I think sometimes that doesn't happen.
my perspective, it does not.
Yeah, I mean, I think I'm with you on that.
Nobody that I represent thinks that their property damage claim
Sure.
is paid on time.
Sure, I
Every
understand.
single person
And
suffers.
everybody thinks that their claim is worth more than the insurer is going to think it's worth. right? And if you're in a liability situation, if I injure you, I want my insurer to make sure that what they pay to you, they should pay you, but that it's a reasonable amount. Now we're going to disagree on what's reasonable, but I want them to fight that, because otherwise I'm going to be paying higher premiums than I should be paying if they pay out too much money. But I agree with you on this. I just think we need to have something down so that everybody knows what the rules are and they're clearer. But let's talk about, we can't get an agreement. All right, there's just a dispute. A lawsuit is filed. Now here, well, before I get into it, let me tell you why I did that. You're familiar with the rules of civil procedure. Right? When a lawsuit is filed, by rule, it's got to be at least a year before the case can come up unless there's an agreement among the parties.
Right.
Right. And that is there in order to ensure that everybody has the opportunity to get the information they need for the discovery process, so that when it does come up, that you're ready to go. Now, hopefully, you also got an ADR requirement in there, a mediation requirement. Hopefully it's going to get worked out. And what these days, probably 95% of the time it does. Fortunately, that's a good thing. But you've got a provision by rule that allows for a discovery process that is, in most counties, probably it's going to be more than a year, frankly, isn't it? I mean,
And the ADR rule?
when before it actually shows up on a trial roster.
Right, yeah, probably at least a year.
It's going to be at least a year in that case. I mean, in most places, some places are more efficient than others, but in some cases, I think I've got a 2014 case in Allendale still. But there's some, now that's unusual too, but some places will be more efficient, but you're going to have a period of time there. And so what I was trying to create here, and looking, this is all, I'm willing to sit down and talk about all this stuff. But the situation that Rob mentioned is real, right? He's going to get a time demand right after he gets involved. It's not a time demand directed to the insurance company. It's a time demand addressed to Rob Mosley. And it says, you've got 14 days to pay. Rob doesn't even know what the heck's going on. And I will tell you that you may not do that. That is absolutely routine. It happens 85% of the time.
Senator Massey, under our case law, that is not, by definition, is not bad faith.
It happens every time.
I don't doubt that the letter is sent, but if we look at the analysis that the court set forth in Hood and other case law, the Tiger River Doctrine would say that is not bad faith, period.
But then you've got to go through this whole process before you ever get to that consideration, right? If it is absolutely not bad faith, then let's say it's not bad faith in the law. Let's put it in the statute and say, right? And look, I don't care about 10 months. That's probably, that may be too long, but you got to give him time to figure out what's going on, especially when the rules already give him time.
Rob and I've had cases over the years, not a whole lot, but if there's video of a wreck and there's video of someone that's intoxicated and I'm killed and there's $1 million policy, does he need 3 months to decide that? Does he need 30 days? Now, if there's a question about who's at fault, then it's going to take more time. It's going to take probably more than 3 months before bad faith could ever be considered. Every case is different. It concerns me that we're trying to pick arbitrary dates when we have a system in place that protects the insured as well as the insurer.
And all I'm trying to do there with the post suits, I mean, once the suit is filed scenario, is just to ensure that he has the opportunity to get the same thing that you've gotten, and that he has time not only to get it, but to analyze it and make those determinations too. It very well could be that it's a clear-cut case. Most of the time, it's probably more of a value decision than it is a liability decision, but it can be both.
One person we keep leaving out is the insured. What does the insured have to say? Rob mentioned he's got two insured, the company in the trucking world, the driver and the company. I guess where our disagreement is, Senator Massey, is I believe that our common law sets forth a system that has been working. It's not shown to be a problem. When problems have shown up, it's stood in and corrected in a way that I think you would agree is an appropriate way to deal with it. And I'm concerned that whatever date we pick, whether it's 30 days or 3 months, the 10-month rule, I think, if I'm not mistaken, is outside the ADR time period. So, I mean, an insurance company, once you're in
I
litigation,
just put the number in there. I mean, that's why I said if it's something needs to be more, if it needs to be less, whatever. I'm just trying to ensure. I mean, the rules give you a year at least.
to litigate it, not to mediate it.
No, that's right. But it gives you a year in order to do the discovery before it's going to come up for trial. It's not coming up any earlier than that unless everybody consents to it.
Well,
But so all I'm trying to do is to ensure that everybody has time, that it's thoroughly evaluated, that Rob can then advise his client. He's got the information. He can advise his clients. And if there's anybody else that he needs to advise, you know what? Mr. Cope's right. Right. I've got everything now. I've been able to look at it. Lee's right. You need to pay the money. Or he looks at it all after he's had time to analyze everything that you've got, maybe take some depositions because things can change with eyewitness testimony. Look at all that stuff and say, you know what? I disagree with Mr. Cope on whether it's liability, whether it's value, whatever else. But right now, not you, but a whole lot of other people are putting him in an impossible situation. Now, and I would say that it is a problem, or else, well, Rob Mosley just told you it's a problem, but it wouldn't be in here if there hadn't been a whole lot of people hearing about it.
and I'm telling you, from our perspective, what insurance companies are doing to insureds and people that are claimants is a real problem.
I'm with you. All right,
What does that do about them?
let's fix that.
What does this bill do to address the greater number of people that have those problems? Because they don't all end up on Rob's desk, right? They don't all end up in his desk. And a lot of my clients don't have a choice to hold out and wait for what they're entitled to. They've got to move on. And so you don't see those people.
Let's fix that.
How do you fix it with this?
I mean, well, let's negotiate a way to fix it.
Well, I can, Senator Massey, and I heard you say yesterday that this thing's got to get moving. I don't see how we can move this section as rapidly as you want to.
Well,
And we're willing to talk. I'm here.
well,
I'm willing to sit down. Rob and I've had cases, we've never tried them. We've actually worked things out our whole career. I'm willing to work with you, but how do we solve this big of a
Well,
problem
I'm going
between
to tell
now
you
and?
this, Lee, and I'm not blaming you for this, but as I told Miss Lynn and Miss Creech at the first meeting on this, it's not their fault either, but there have been multiple requests. Some people have begged for conversations for years on these issues, and the answer has always been no. Right? We're not talking about negotiating things. The answer is no. We won't even talk. A few years ago, when we had a debate in here about COVID liability protections, we were begging businesses to reopen. They wanted to reopen. They were scared that they were going to get sued if they open and a customer gets sick or an employee gets sick. Right? We were trying to pass some protect just to give them a morale boost, really. I mean, frankly, it didn't do a whole lot. The level of opposition that we encountered to doing something that didn't really even do a whole lot was indicative, I think, to a lot of people of just how, I mean, like, there was no willingness to talk about even that. I appreciate, like, I wish you'd been involved in this from the beginning, because I think you and I and others, we could sit down and we could address most of these problems. But it's not, I think it's neither fair nor accurate to say we're rushing this along when there have been multiple requests to try to address a number of things and nobody's willing to talk. And then all I get in response is, well, you're just a corrupt, evil, greedy person who's on the take.
Well, I'm called a greedy trial lawyer, so I understand where you're coming from. But here's what I would
Yeah,
say
but
to
I
all of
would-
that, Senator Massey, is
That's I get that. And I guess any of us who are in the profession are, but I bet you haven't had your colleagues saying you've been bought.
I can't address things I don't know anything about, Senator
Well, I
Massey.
bet, well,
But I can tell you
I
this.
bet you haven't had colleagues in the legal profession people you work with who say, you've been bought. You, right? I mean,
I don't know how to address that in the context of what we're dealing with here. Okay,
well,
because what I would tell you is,
I want to talk about these things. I especially want to talk about this section. I knew this section needs a lot of work, right? And we can hear from y'all some more about any other ideas on this point. But I do think we need something. Maybe we do have a disagreement on this. I do think we need something so that everybody knows what the rules are. Because even though your perception may be there's not a problem, Rob's perception is that there is, and his perception is not limited just to him.
perception is not data. Perception is not evidence. Yesterday, when we had the discussion about medical malpractice lawsuits and whether there was gross negligence was causing great numbers, we did a LexisNexis search this morning. In 10 years, there have been 21 medical malpractice verdicts for plaintiff across the state. It's not, again, there's a perception. Sonny Barnes has every reason in the world to believe that this is a problem because that's his perception of where he's coming from. And all I would say is that perception is not data, because I can tell you, I can line up lawyers to come in here if Senator Johnson would let us, and I know he won't, to tell you about how many times a day they get phone calls from somebody saying, my insurance company won't pay for this. They won't pay for this. They won't pay for this. It's a real problem.
You know, Mr. Cope, that the fact that there aren't as many trials doesn't mean that the current law doesn't affect those things. There are settlements that are higher than they need to be, higher than reasonable, because the law is that you won't agree with me on this, but my position on this is they settle things that they shouldn't settle because the law is not what it ought to be, right? They've got this hammer hanging over their head. Now, there are absolutely situations where there ought to be massive payouts. There are situations where there ought to be extreme verdicts because unfortunately, you have people acting in such a manner that they deserve those types of responses. But right now, what he would tell you, I suspect, if he were here, is that the current state of the law is having an effect on settlements that they feel like they're paying more than they should. They can't take the risk of the trial, and therefore those premiums are increasing because they're paying out more than what they ought to pay out.
Never had a client feel like they had a windfall in a med mal case. Every
No,
single
they're
one.
never going to feel that way.
Well,
Right,
neither is Sonny.
feel that way.
Neither is Sonny Barnes, right? But my clients don't feel like they got a windfall. They don't think they got more than they deserved. Every single one of them would turn that money in to go back and reverse the clock. So I don't think it's fair to make that type of an analysis.
Well, but you have to. But that person can't make the analysis.
Neither can Sonny.
No, that's right.
Neither can a defense lawyer, with
he
all due
can't
respect, because
He
there's a
can't
bias
either.
built in.
It's got to be in some things, but not. I mean, I don't think you're biased on everything that you're talking to me about. I mean, I think
I'm partially biased. I don't deny that.
But I also understand. I mean, I think you've got the experience. I mean, I think you're giving me straightforward testimony, and I think Rob is too. Now, granted, you've got different perspectives, but I think we can sort through that stuff. But that's the reason I think that we have to take a step back as policymakers and try to make the best neutral decision. What's best for the injured person, the claimant? How do we balance that? How do we balance the injured person, the claimant, versus business and individual citizens who are paying the premiums as well? How do we balance that? Because, and we would probably disagree here. My position would be that we are out of balance, that we lean too far the other way. And I think when we look at other states in the region, in the Southeast, I think we see that. But again, I'm willing to talk about anything, especially with you.
Well, I'm available, but I don't know how we get look, I'm a very optimistic person by nature. I would love to think that we could sit down, me, you, Rob, whoever, sit down and have this hammered out tomorrow. It's not likely. If you've got it on a short rope and we know we can work on this,
Well,
what's
going to happen, Lee? If we give more time for this, your organization, not Lee Cope, there will be other people in your organization who will work very hard to delay it in the House. But beyond that, if we sit down and we reach an agreement on something, you're going to go to the House and you're going to negotiate another agreement on it. I don't have any confidence that if we make a deal, that your team's going to stick to it.
I feel like we're getting into a team battle here, and I don't think that's an appropriate thing. I wouldn't be here if I was secretly working on some deal with people I don't know in another body.
Well, you
Here's
tell
what I'm
me,
here to do is to sit down and try to negotiate.
can you sell it? Can you hold it?
Well, it depends on what we're putting together. Same with you, right?
If there's something that you could agree to, could you sell it?
Yes.
And it would hold in the house.
Now I can't answer for that.
Well, then that makes it more difficult for us to sit down and have the conversation.
Do you ever have that level of certainty?
Yes.
I'm not aware of it. I'm not aware of anything that this body,
Yeah.
you know, I meant to mention yesterday, if I appear a little nervous, I was here 30 years ago, almost to the day. And I'm not nervous to be in front of y'all, but in front of my former boss, Sharon, okay, she doesn't want me to say it, but she was here 30 years ago. I was here before you, Senator Massey, as a law clerk. And I got to witness how these things worked. I was here during Senator Marshall Williams, which shocked me to see on this board over here. That's how old I am. Hired me. Don Holland kept me on board. I was here working with him and Senator McConnell. I got to see bipartisan work on things that matter. Okay, it was a shift away from democratically controlled General Assembly, and we saw that moving into the Republican controlled. But there was always an earnest desire to do the right thing. But even with that, I saw that there were huge disputes between the Senate and the House. Sometimes the thing we're arguing over had nothing to do with what the deal was being worked over. For me to tell you that, can I sell this? I'll certainly try. If we can reach an agreement, I'm more than happy to go over and say, we've got language we can agree on, but I would never stand here under oath or not and look you in the eye and say, yes, if we reach a deal, then the House will buy it. I don't know how you can expect, how do you expect me to answer that?
I'm not asking that. What I want to know is if you could sell it to other plaintiffs' attorneys, because what's going to happen is once we reach an agreement, they're going to go over there and negotiate something less. And then it's going to come back and there are going to be people negotiating something even less. It happens every time.
I don't think they would have asked me to be here if I didn't have the opportunity to try to work out a deal with you. Now, with me working on behalf of my organization, this isn't Lee Cope and my law firm striking a deal with Senator Massey. This would be our association working with you to try to come up with a thing that works for the citizens of the state. What more can I offer you?
Well, look, I appreciate you being here. I think you're working in good faith. I just don't attribute that to others.
Well, everybody I'm working with is working in good faith to get this resolved for the people of our state.
I'll tell you this, not everybody on the board of governors are. Okay. Those are the decision makers. But let's set that aside.
I'm on the board, so I'm here.
All right. Well, look, I'm willing to do that. We've got this weekend, we've got next week, right? And hopefully we can get some time with Rob and we can have some other people and we can talk about things. But look, I guess it always depends on where the votes are, and we can, and we may just have to find that out. I'm willing to do that. But I'm willing to talk. I'm not willing to delay it inevitably forever.
I'm not asking for that at all.
Okay.
But I don't want to put ourselves in a situation where you think we're playing games. We're not here playing games with you, Senator Massey. I can't
You're not going to convince me of that.
I can't tell you what happened in the past because I wasn't part of whatever conversations you're referring to. I can tell you that this spring, we are here in earnest, in good faith, to try to do what's right for our clients that are the citizens of this state. And I think you are as well, or else we wouldn't be here asking to negotiate with you.
I believe you're here in good faith. I'll leave it at that.
Then let's get to work. We can agree that the 3-month and the 10-month time period set forth in the bill as it stands is not realistic and it needs work. And I think we can work from that, knowing that if we didn't accomplish anything else today, knowing that, then there's room for us to sit down and talk about what is reasonable, recognizing that a compromise, whether it's in litigation or in legislation, nobody's going to get everything they want. We're willing to work together to try to reach a resolution that helps people in this state. That's all I can offer you.
Okay. All right. Well, and it's not just you and me. There are others who may want to be involved, but Rob needs to be involved and anybody else who needs to be involved. I want the right players in the room.
Absolutely.
But I'm willing to have I've always been willing to have the conversation. Thank you.
Senator from Charleston.
Thank you, Mr. Chair. So Well, a couple of things as I was jotting it down. First, I just want to say that in all of my time in the General Assembly, both in the House and the Senate, this is probably the most productive subcommittee that I've seen. And I told the chairman that yesterday, that we've been having real meaningful conversations. And I believe that everybody who's come to testify has come in good faith. And I've never seen in a committee where opposing sides are willing to work together to do something. And I'll just use for examples when it comes to the doctors and whether it's the MDs versus the physicians assistants, we can't get them to agree on anything. There's never, it's either this is the bill we want or it's not happening. And here we have people on opposite sides willing to work together. I do agree with you that there's a lot. There's 16 plus whatever sections in here, and then the fact that this bill is really being used under the guise of, the restaurant industry and alleviating premiums. And speaking of playing games, we're all here. We have demanded to hear from the insurance industry time and time again. They have refused to come to the table. We don't know how these what the calculations are, how they do these rates, because nobody wants to come. Your association is here. We appreciate it. You are here in your association, and we appreciate it. We have yet to hear from the industry that we are looking to help who won't even come to the table. That's one issue. But to your point about why we can't codify a time is because what I believe you were trying to say is that there there is a case by case scenario. And so an example I thought of was if say we codified 50 days, and so you got a car wreck, because I won't talk about homeowners. We got a car accident where they just happened to be caught on dash cam. Somebody blows through a red light, creams another vehicle. Those people are injured. We got the medical reports from the doctor that says this person broke this limb. It was a direct cause of this collision. We got the BAC from the driver. I mean, so if you send a letter to the insurance company, you've put them together what you had to wait to request and get, and you put a packet together with all of the medical records, an explanation or summary about the case, the video that clearly shows the car blowing through the stoplight, the charge for the DUI, the BAC in there. I mean, that is the outlier that would essentially, you don't need 60 days to determine whether or not that should be paid on. And so my pause, and I think is what you were trying to say, is if we codify a time limit, then we do a disservice for those victims and those claimants. Do I agree that with you that the 2 week, somebody just sending a letter and it's probably not much information there other than some blanket, this happened on this date, my client suffered these injuries, we want the limits, you got until next Friday. That's not reasonable. I agree with that. And I think he agreed as well. And based on the case law, that wouldn't even rise to the level of a bad faith claim. And to that brings me my question to you. How many times, because I'm curious, how many times have there been a bad faith claim or granted based on something that was really unreasonable, such as that? Is that happening?
I get a Tiger River demand in almost every case.
Right.
And I'll tell you that I got one from a lawyer from Charleston, and I have $1 million policy.
I haven't sent one in a while.
Not anybody in the room.
I'm up here too much.
He sent a letter. He gave me 1 week, and he had $7,000 in medical bills that were chiropractic medical bills, and he demanded the $1 million. He wanted $1 million. Because he did it, I had to prepare a response within 7 days. I had to go to my clients. I had to talk to them about it. They didn't understand it. I tried to explain it to them, and
But you didn't have to pay that policy in those 7 days. To respond, yes. You can say simply, "Hey, I don't I don't agree. I've sent letters where I get a response with a offer way different from what and do I go file a bad faith claim off the rip? No, because we have a time to discuss. And the point is, if that were to go to court, I don't see where the court would say you acted in bad faith by not paying out that policy based on the facts that you have given. And so when I say, is this happening? Okay, yes, there may be lawyers sending these letters because they're lazy. They just want to get a quick settlement and they don't want to go through the work to actually work up the case. But that does not in itself, that is not in itself a bad faith claim.
But it's a setup for bad faith. It's the idea is that the lawyer is trying to set up the insurance company that if you don't pay my demand and I have to go get a verdict, I'm gonna put you through this process. Now, what I would the way I would say is that let's have a rule for how you play that game. I understand the game. I understand the way it's played, but let's have some rules for how we play that game.
And so going back to my first scenario, the video and it's not often, well, maybe now with more dash cam, but I mean it's very rare that you catch an entire collision on camera and it's clear. I mean, you got the report, the medical reports, the video, the BAC, all that. I mean, would you agree that in those scenarios that does a disservice to that claimant who really needs to recover and move on? And so if we set it 50 days and so now you can just say, well, I mean, I know we need to pay this, so but we got 50 days, so I'm just going to wait. I'm going to get to this. I mean, and you don't think that will happen?
Most of
the same way we got lawyers sending unreasonable letters, you don't think there's going to be some defense attorney that, well, or not even a defense attorney, because I've worked with plenty of defense attorneys that are like, I agree with you. It's my carrier. They won't even listen to they won't listen to who they hire to tell them when you're trying to give them the legal expertise, this is what we need to pay out. I've seen it. And so it's not always the defense attorneys. It's sometimes your clients. So, but
it could be. And I think your point is that you don't need that much time in some cases. And normally liability is going to be, you're not going to have to work too hard to figure out who was at fault.
Right.
There are cases where that's not the case. And there are liability disputes, but most of the time you're talking about damages.
Mm-hmm.
And so the issues turn into, okay, the demand comes into me and it says, this guy's got a head injury and he's never going to work again. Okay. Well, now I've got a lot of questions I have to ask. I have a lot of things I have to understand because this person's claiming a TBI and saying I can't, I'll never work again, or I've got I'm going to have surgery on my back. Not I've had surgery on my back. I'm going to have surgery on my back, and I'm never going to work again. I mean, those are the kinds of things that I deal with more often than liability issues. Is that I just don't know enough about the damages.
Yeah. And that's different. And that's on the other side where, again, how do we? I just don't see. I'm just going to the point where I don't think we can codify a time, because in those situations, okay, perhaps you need more time. But in the example I gave, I mean, I don't know what else you would need. I mean, from you got the 911 call we sending over, the video, the BAC, the medical records that show this person broke their whatever, this was fractured, and it's a direct cause. The doctor saying this is because of this. No prior medical history, no degenerative disc disease, none of that. It's just clear cut. I mean, in that instance, then we'd be hurting that plaintiff or that claimant because we decided to codify something which the law already covers. Because if it was unreasonable, then the court would not hold you to the standards of a or rule that you admitted or committed bad faith.
Well, I do think we need some parameters. We need some rules for how the game is played, and whether it's 30 days or 45 days or what have you. I'd be happy. But as long as it's not a week and somebody, putting all these onerous demands on what I have to do in the next week.
Okay, well, I agree. I mean, you all said you're willing to work together. I would like to see that. Again, I think this is probably the most productive subcommittee that I've ever been on. I mean, it's legitimate debate about legitimate issues, and it's not really combative. It's just differing of opinions, and then we say, well, we actually agree on these things because we're having a conversation. And so I don't want us to. I don't know if a weekend is enough. I know that's not enough time because you got stuff you got to do too. So we can't just give you a weekend to say, get an answer next week, or we can't do it. And so I think as long as the parties are being reasonable and working together, we can continue these conversations. But something will have to be done at some point. So I just appreciate you all being here. But I did just want to point out those things and bring up that issue with the time limit being codified.
Senator from Richland.
Thank you, Mr. Chair. And this is for Mr. Mosley. And Mr. Mosley, I don't think you've ever gotten one of my bad faith letters.
I don't think I've had the privilege.
Yeah, well, just know at the end of mine, I usually ask, the carrier to do the hokey pokey and turn themselves around when they bring the check to my office. Now I'm teasing. So we're talking about, probably needs to be said. But in any event, we're talking about a bad faith letter that's been sent, after litigation has been initiated. And, my experience has been that usually the attorney for the insurance carrier, you can get access to the medical records, without having to go through the discovery process, at least at the outset, as far as what has been submitted by plaintiff's counsel, to the carrier, right? Because of the demand may have gone out previously and perhaps, prior to, litigation. And at some point, plaintiff's counsel thinks that the insurance carrier is not acting in good faith. So suit gets filed and then the bad faith letter goes out. So usually you don't really need, I would say, 10 months, 8 months, or even 6 months to at least get your hands on the medical records to begin to make, I guess, some sort of assessment about damages, right?
Like Senator Massey said, I don't know that anybody's wed to that 10 months or whatever. I think that the way it should work, I mean, is that the plaintiff's lawyer says, here's everything. And then you get the demand that says, okay, you now have everything. You got, and I think in that situation, in the litigation situation, you do need a little more time because
and I would agree with you.
You
certainly need the time.
If we start sending out subpoenas, we get ignored the first couple of times, and then we finally get records, 40 days later, then maybe we've gotten back everything we need 40 days down the road. So, I mean, I'd be happy with 60, 90 days instead of 10 months.
Well, and I was going to ask, because I know that at least what I've gleaned from your comments and Mr. Coates' comments, is that certainly every case is different, right? And I was my follow-up question to you was going to be, how much time do you need, once you receive the bad faith or the Tiger River letter? At a minimum, you've been able to get your hands on the medical records or any other documents that have been sent to the insurance carrier prior to the filing of suit, right? So now a lot of plaintiffs' lawyers, if you're like me, once I learned that there is a defense lawyer has been assigned to the case, I will just take the initiative and send you everything that's already been provided to the insurance carrier. But of course, I know you can get that same information as well, from the carrier. So assuming that the plaintiff's lawyer sent you the information or you've been able to get your hands on it from the carrier, how much time would you need in most cases? Would it be 60 days, 90 days to respond to a bad faith letter?
I think 90 days would be great. I think 90 days would be plenty of time.
And we're talking about automobile cases, by the way. We're not talking about homeowners or any other.
And that's what the bill addresses. So yeah, auto liability claims.
And Mr. Coates, does 90 days, up to 90 days sound unreasonable to you?
It's a case by case basis. I mean, I think it's a lot better than 10 months, obviously.
Automobile cases now,
Right.
that's what we're referring to.
Sure. Let me tell you why I brought up, if I could, Senator Walker, why I brought up homeowners claims. When we start down this path, it's going to open it up to the homeowner policy insurers to say, wait a minute, we need time too. We want statutory time. That's a concern. If you go down this path, you're opening the floodgates to every other type of insurance. It's not going to stop here. Okay. And that's a real concern of ours. It's a real concern of mine for sure. Certainly 90 days in litigation is a whole lot better than 10 months. But let's think about how most of these litigations start. As Rob has already mentioned, you've already given them 30 days on the front end prior to filing the lawsuit. Once I filed a lawsuit, it's 30 days before the defendant even has to answer. Are we talking about 30 days from the date 90 days from the date I file suit? Is it 90 days from the date I serve the defendant? Or is it 90 days after Rob gets involved? Because a lot of times when we're negotiating, we're not negotiating with Rob. I wish we were. As you mentioned, it's a whole lot better, with all due respect, to deal with you or Rob than it is an adjuster. But when do you start that time? This doesn't address that. Okay. This bill doesn't address that. We need to work on it. We're willing to do that, but there are some real concerns. Again, I can't help but state over and over again, and I'm not a cheerleader for our court system. I'm part of it, but we do have a very good system in place. What Rob hasn't addressed is how many times has his decision been subjected to a bad faith lawsuit that ended in a finding that there was bad faith on the carrier's part. There's data out there. Now, Senator Massey would tell me, yeah, well, we settle because we don't want to get caught in the trap. Plaintiffs settle because they don't want to lose. So we can't really look at the fact that cases settle. That's what we want. In fact, it's our court's preference. So there's all kinds of factors that go into settlement, but I don't think anybody can point to data that shows that bad faith lawsuits are being filed and juries are returning verdicts that our courts are upholding. In fact, I believe the evidence would be the opposite, that almost every time, especially where there's shenanigans like he's described and you've expressed concern over, our courts have stopped those and not allowed them to recover against the carrier.
Any other questions? Gentlemen,
for
thank
your
you.
time.
We're going to move to section 7. Ms. McVeigh, come on up. Who's gonna champion the other side on section 7? Rob, you're back. You didn't have enough of this already. You're still under oath, Ms. McVeigh. If you raise your right hand, do you swear to tell the truth? Your testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
It will.
Thank you, ma'am.
Thank you, Mr. Chairman and members of the committee. The good news is, I think for everybody, is I have a good idea of a great compromise for this section. And then Senator Massey, with your permission, I want to talk to you a little bit about what I feel like your position at Skage's prior history on negotiation, because I think I've been a part of a lot of the negotiations. And so I want you to be able to ask me questions about that, because I know you and I have known each other for a long time. 25 years at least, same law school class. And I know we've had a lot of various discussions, including about COVID. And I want to talk to you about that if you want to.
And Teely, I'm happy to talk to you about, I'll talk to you anytime you want to talk.
Okay.
I don't know that everybody else needs to hear that, but I'm happy to talk to you about that whenever. But,
Okay. All right. So you actually came to Skage's convention with us and we debated about the seatbelt bill. And I think that was probably 10 years ago. I mean, I think I moderated a panel on it. And so the way the new section reads is a violation of this article, meaning the seatbelt law, is admissible as evidence of comparative negligence in a civil action. And I think that's the wrong way for this to read, because using a seatbelt or not using a seatbelt doesn't cause a wreck, right? I mean, it doesn't cause it. I think what you're trying to get to, what this committee may be trying to get to, is a mitigation of damages type sentence. And so what I was wondering is if this language might be appropriate. A violation of this article is admissible as evidence if the violation is a proximate cause of the claimed damages. You see what I'm saying? So what I think the seatbelt goes to is whether or not it would have prevented more extensive damages. Whether or not one is wearing a seatbelt has nothing to do typically about whether or not a wreck occurred. And so that's the objection to it.
Mr. Chairman.
Senator from Edgefield.
And I understand that, except the elements of negligence include damages.
Right, but you can't say something is comparative negligence, right? It's got to be approximate cause of it.
Right.
So-
So that's part of the elements of negligence too.
But I guess what I'm trying to tell you is if we're just talking about the damages, and that's what you seem to be talking about, if we add that language in, you get what you want.
As long as it allows for a reduction or some attributable amount that the jury's going to have to include to talk. I mean, we can talk about that.
So there's
but-
two, I'm sorry, I didn't mean to interrupt you.
No, you didn't.
So in my mind, there's two different things. There's comparative negligence and there's mitigation of damages in some ways, right? So the seatbelt to me is a mitigation of damages. In other words, would you have whacked your head if you'd had your seatbelt on afterwards? But I don't know that it's comparative damages, but I think it does go to what damages are related to the wreck itself. That's why I think that language is important. Does that make sense?
Senator from Richland.
So, and when I read, that provision, when I read it previously, I kind of had a similar thought. But for me, it was the scenario where someone gets, I don't know, rear-ended or what have you. They're not wearing their seatbelt and they go through the window.
Right.
Right. And then you have, serious or maybe some catastrophic injuries as a result of not having the seatbelt on. And then, because you're right, not wearing the seatbelt has nothing to do with the issue of liability.
Right.
But once we get into the issue of damages, proximate causation, okay, well, the initial impact, by the at-fault driver, is that the proximate cause of the person going through the window and ended up with brain damage
Right.
or, a fractured limb?
And I think, that evidence of whether or not the seatbelt would have made a difference in terms of the damages that are made, you could get to it through expert testimony or whatever. But just not wearing a seatbelt in and of itself is not comparative negligence unless it does something to make the damages worse.
What if the language were to read as opposed to is admissible as evidence of comparative negligence? May be considered?
I think-
maybe changing that word, changing is to may.
I think that's a
Would
great
that be a
idea.
fix?
I think if you say a violation of this article may be admissible as evidence if the violation is a proximate cause of the claimed damages. In other words, the failure to wear a seatbelt would have to be a proximate cause.
Gotcha. Thank you. Nothing else for me.
Anyone else? Rob, come on, tell me why this provision is perfect.
Well, Senator Massey's been behind this for a long time. So I don't care what the words are, as long as the jury hears that somebody made themselves more injured by not wearing a seatbelt.
So you would agree that adding the, and everybody needs to see it in writing, right? We're just saying it out loud, but that the proximate cause, that there has to be a link, right? It's one thing, I'm driving down the road, I don't have my seatbelt on, something goes through my windshield and kills me. It didn't matter if I had a seatbelt on or not. It's a whole nother thing that I got hit in the head because I'm not bothering to wear it. And so if it's a proximate cause, it should go to mitigate damage. I mean, I don't have any issue with that and actually agree with it. You should be wearing your seatbelt. So in theory, that sounds like something you don't have to say I'm all in. I'm just trying to get us somewhere.
Well, I think we go back in history and we look at the beginning of the seatbelt law in South Carolina, and this was a compromise to make it acceptable for people who don't want to be told that they have to do something. And so, I think we're 30 years past that. and whoever had those feelings now is long gone, or back then is long gone now. And so I mean, the optics of a state that doesn't say that, your actions, you're going to be held accountable for your actions. And we're going to hold you accountable unless you decide you don't want to wear a seatbelt. So we're going to put that one over here and just make that all different. But anything else you do, that we're going to hold you responsible for your own actions. But not
the cause of those actions. I mean that's
or mitigation. I mean, if you don't do what the doctor says, or that's a mitigation issue. If you're told that you can fix your problem by doing these exercises in physical therapy and you don't do them, then I mean that's a mitigation issue. But not wearing a seatbelt is a mitigation issue, or however you want to put it. But I'm not wed to the language. But the jury needs to know about people who don't wear seatbelts.
And it sounds like, just based on the testimony, we're going to get there. We're going to get that this is admissible. The question is how it's worded. And I think that's a positive step. Anybody else with any questions? Back to the senator from Richmond. Oh, I'm sorry.
I just want to make sure, just because what I heard Mr. Mosley say is the jury is going to hear when somebody doesn't wear a seatbelt. I don't think that's what we're agreeing to at all. What we're agreeing to is it relevant if somebody's not wearing a seatbelt, if it's a proximate cause of an exacerbation of their damages? That to me is very different than as an aside, so-and-so wasn't wearing a seatbelt.
Like I said, we're going to have to see this in writing. So, yeah.
And I'm happy to work with anybody on language or however that works as well.
Senator from Richmond.
Thank you, Mr. Chair. And questions for you, Mr. Mosley. Kind of playing devil's advocate here a little bit, but with this change, do you think we could potentially, I guess, open the door for, I don't know, in a personal injury action where you have someone who's on a motorcycle? I think the law in South Carolina doesn't require individuals to wear helmets. And I believe the argument is it's all about personal responsibility and freedom, right? And so if someone is on a motorcycle, they're hit by a car and they're knocked off that motorcycle, end up with a brain injury. If you're defending that case, or would you be arguing that would you be arguing comparative fault, and that the lack of a helmet, although state law doesn't require it, but the lack of a helmet is the proximate cause of that person's damages. Hence, he or she should be barred from recovery.
Well, I think we've got a similar law on helmets. Don't hold me to that. I haven't looked at that in a while, but I'd go back to Miss McVeigh. I mean, if my truck hits a guy on a motorcycle and the helmet ain't going to make any difference, then that's not going to be something the judge is going to let me put in. If it would have made a difference, and that's back to her point, is it doesn't apply in every case, but if it would have made a difference. In your example, he's got a head injury, and the evidence would show that he doesn't get a head injury if he's wearing his helmet. Then I would take the position that should be admissible.
Okay, all right, thank you.
One last.
No, the only thing I want to say is I think so many of us are willing to compromise on lots of these issues, and so happy to talk at any time with anybody if that's ever helpful.
Thank you both. Thank you both. That is it for people who signed up to talk about the sections. I will say, because I pointed it out yesterday, to my note taking at least, sections 3, 4, 8, and 14 have not been addressed. And doesn't mean that they don't need to be, but if you have an interest in talking about any of those, 3, 4, 8, and 14, and just for knowledge, we have found a scrivener's error in section 3. It references in 61.3.110, paragraph C, a section 61.2.145E. Well, there is no section 145E in the South Carolina Code, and there's not one in this either. So there will be a amendment at some point just to take that out. We just think that was a pure accident. And it's in there twice. It's also in 61-3140, a reference to it. But just so if you are digging around and looking for it, you will not find that. Anyone, I'd love to hear if anyone has anything to say about the alcohol server training. Other than I think there's been general consensus that we agree with it, but if you have technical changes to it, that's otherwise. And then of course, then you have section 4. Section 8, which talks about jurisdiction, looks like, or where we're going to try the case. And that's 8. And then 14's near the very back. Yeah, it's kind of, yeah. All right. So, excellent.
Mr.
All right.
Chair.
Yes, sir. Senator from Richland.
I think Section 8 deals with jurisdiction when there's a John Doe, defendant. Right, venue, when you got a John Doe defendant. And I guess for me, I would love to hear if there's anyone in the audience that has thoughts on this, but to me, I don't see why we wouldn't treat a John Doe defendant the same as a non-resident defendant. I mean, under, I think it's section 15-7-30, subsection D of the code, when you have a non-resident defendant, the case is tried in the county where the action occurred, where the incident arose rather, or where the plaintiff resides. And so if we've got an unknown defendant, I would think, to me, that's tantamount to a non-resident defendant. And I would think we should just treat that unknown individual the same as we would a non-resident defendant.
Senator from Edgefield.
Senator, I think that was the intent. No offense to Mr. Cope, but the 14th Circuit has a different reading of that. And so there's got to be some clarification on that. I mean, we have John Doe cases that happen, a John Doe car accident that happens in Spartanburg and the lawsuit gets filed in Allendale. And or Hampton or Orangeburg or somewhere like that. I mean, that's what I'm trying to address here.
So, Senator, in those instances where the suit is filed in Allendale, well, obviously, I'm assuming that is not where the incident arose. Is that where the plaintiff resides as well, or?
No.
Wow. Okay. Yeah.
How did it get there?
Yeah.
It's filed there, and the judges have not been willing to move it because they say that statutory scheme is unclear, that John Doe should be a non-resident.
Right, but as a non-resident under the statute,
We don't know that it's non-resident.
Right, we don't, and so because that person's residency status is unknown or undetermined.
Well, the allegation is that John Doe lives in Allendale.
Oh, okay. Well, I disagree with that.
So does most people in the civilized world, but that doesn't mean it doesn't happen.
So
I'm telling you, it happens.
Yeah.
It happens. It's not irregular.
Gotcha. Well, you would agree with what I'm suggesting, or
I think that's what I think when they put that venue provision in the law, that's what they intended. And in fact, I think if you look at the whole statutory framework dealing with venue, I think you can read that that's what they intended. But there are many cases where that has not been effectuated. So that's what I'm trying to address here.
Okay.
It's 240, 245, 247. There has been some discussion amongst the members of the committee that we're going to discuss in terms of parts of the bill and have an open discussion about, areas that we think might need some changes, but that amendments, actual formal amendments, will be handled at the full committee level, where there is a greater representation of the body. And so the goal is that if you have something here and you're like, this is something I think we really need to take a look at and kind of start getting at least this group thinking about that, this would be an appropriate time to have that discussion. Or you could say it's Thursday afternoon and it's 2:45 and I'm ready to go home. But I'm happy to sit here and talk. I mean, I'll start this and quite honestly, I'll just kind of bring up thing up. Section 2 deals with alcohol liability. Mr. Berger had numerous suggestions that I agreed with, removing, adjectives like visible, changing out of obvious to apparent. At some point, I am certainly there is a provision in here that talks about selling alcohol to minors. And it removes what the common law has as a negligence per se, which exists today under the common law. I've tried to think about this, and I certainly see 18 and above, perhaps removing that. But if you're selling to what I consider a 17 and younger, you're in high school, you are a young child, and you're getting alcohol, I would still want that much stricter level of compliance put on them, and perhaps we give some more flexibility to the 18 to 20-year-olds. I'd also be curious. I know the restaurants brought this up yesterday, and Senator from Edgefield, perhaps you could chime in on it in the next section, section 4, or excuse me, section 3, the alcohol server training. 61.3.160 has a suspension for first offense of 6 months. And I got the sense from them yesterday that they thought that was rather harsh, but I'm also I'm curious what the thinking was. I mean, I certainly want people who should, if you're doing things the wrong way, I want you out of the business. But I'm just wondering if first time out is that appropriate?
Mr. Chair, I'm sorry to interrupt, the Senator from Edgefield. Before we move to section 4, can we just stay on the dram shop bill
Sure.
just for a second?
I apologize.
Before we move, no, it's okay. Before we move to section 4, I'm looking at subsection B and subsection C of that statute, and I'm wondering if we should change the wording from actual damages to just damages. If you look at subsection B, Senator Massey, it just says simply liable to a third party for actual damages.
In 244, it just says damages, I think, at least the bill.
Right, 180.
Right, well, I'm sorry, this is
184
This is
says
184.
actual, but 244 says left out actual. And so, yet I agree, it should just say damages.
Yeah, I'm thinking just damages. Get a savvy defense lawyer, and I can see them easily arguing, well, your damage, the plaintiff who's been injured, you're just limited to your actual damages, and that takes punitives, off the table. So I would suggest that the language simply read damages as opposed to actual damages.
And it certainly does in 244, and
Okay.
we can at some point amend 184 to
I don't want to
reflect
be
that as well.
duplicative, but
No. Thank you.
All right.
Anybody else want to kind of chime in on dram shop before I shouldn't have moved on without letting everybody, if you had something to say on it.
Mr. Chairman, on that, I would say, I would hope that the folks that we had yesterday with Mr. Blake and also some folks who testified on this at our first hearing could try to work on some language on that part. I know, I thought Mr. Berger's testimony was very helpful as well. He wants to include the would become language, and and I understand that. Also understand why some of the hospitality folks say that doing that could make their insurance situation worse. But I do think if somebody sells me, your example with 6 shots of tequila, I may be fine while I drink it, but in about 30 minutes or less, I'm not going to be.
Yeah.
And I think that's going to happen. Now that probably doesn't affect Mr. Blake's clients. His clients aren't doing that type of thing, but his clients aren't the ones that are really the problem areas anyway. But that gets to, as I said yesterday, I would hope that those people who play in that sandbox could help out there to make sure that we do it right. But that gets to the other question you asked about section 4. I think it was section. No, what was it? Section 3.
Section 3.
Look, I think the alcohol provisions are provisions that everybody's interested in. It's something that we've all heard a lot about. I don't think this bill, certainly it is not limited to alcohol, nor do I think it should be, because I think the problems are much broader than alcohol. And the fact that that may have been what's gotten the most media attention doesn't mean it's the only problem. I think there are other problems we need to address, which is why the other stuff is in the bill. I don't know what's going on. I don't know what's microphone, but in any event, the alcohol part I think is important. What I want to do though is I want to help the good actors, help them with being able to access insurance, and I want them to be affordable. I don't want to remove the mandatory insurance requirement, because I think if you're selling that type of a product, it makes sense to have liability insurance. I don't want to do that. But I do think they ought to be, but if you're going to require it, they ought to be able to get it. Now, where I disagree with some people is whether this has any impact on that. I think it absolutely does. But this provision that you asked about, the bottom of page 10, well, you don't have it that way, but it's 61-3-160. While I want to help the good guys, I think that also means that we've got to call out and punish the bad actors. So if there are people, especially, and Mr. Berger talked about this when we had the hearing on 184 earlier. He was talking about some bars that were repetitive bad actors. Like, I think those people ought not have a license. If you are repetitively over serving people and you know it, or you fit whatever the guidelines here, then I think we ought to revoke. Now the question is, how many chances, this gets to your question, how many chances do you give them? And do you give somebody a slap on the wrist first? But then they got to get out of jail free card. I want to deter people, businesses, restaurants from over serving folks. Now, I don't know how much this all factors into that. I think when it gets to the Senator from Charleston subcommittee, more so on the criminal side. But this provision dealing with the administrative penalties, I'm willing to talk about this, but I don't want like a $1,000 fine, because if you give them $1,000 fine, that's not really a deterrent. But I think we need to send the message that we're serious, and we're putting the mandatory server training in here if it goes that way. But I think we need to send a message that we are serious about restaurants and bars ensuring that their servers know what to do and that they're properly serving people. But if they are not doing that, then there's going to be a real consequence. And it's not just with insurance premiums. If you are not doing what you need to do, if there are people who are over serving folks who are intoxicated, and you can tell that by whether it's visible or auditory signs, whatever, there's got to be, like, those people should not be licensees. Otherwise, you're putting everybody else at risk. So is 6 months too long for a first offense? I'm willing to listen on that point, but I do think from a policy perspective, I do think we need to send a message that we're serious about this and we want this to stop. It's a tough penalty. I agree with that. 6 months on the first one, the second one, you're done.
It's probably the 6 months, probably the death penalty alone for
it
the
very
average
well
bar.
It very well could, but my intention there, and I did that intentionally because I want to get their attention. I want them to do what they need to do to prevent their staff, to get their staff not to overserve people. I'm open to whatever else. I just want to send a message that, I want us to change our policy on this. I want us to be harder on overserving.
Senator from Charleston.
Yeah. So, and I agree that we have to figure it out. I do think, in talking with some restaurants and bars in my area, the 6 months for a lot of potentially the smaller ones, I mean, that would close a lot of people down. Now, I do think that I would not be opposed, and I know you mentioned, you know, you don't want to slap on the wrist, but for those instances where you have those good, you know, bars or restaurants that are doing what they're supposed to be doing, they got the service training, and on a first offense, they somebody under overserves or serves somebody underage, and um, you know, I think maybe you say up to and give that discretion to, because it could be based on the factual scenario, because maybe that bar doesn't deserve a 6 month because now the owner has been alerted that this is an issue and they can take their own, if they're the responsible good actors, now they have an opportunity to correct it themselves. And then if it happens a second time, I can't argue with that to, you know, suspend the 6 months or what have you. But I do think for a first offense, it shouldn't be a definite nail at the 6 months. Maybe you say up to, and then the administrative, they can figure that out based on, you know, what played out. Did that server receive training and all those types of things. I would like to give them a little bit more leeway in the first offense, because then it's brought to the knowledge of the owner or the operators, and at that point, because they may not know what, you know, and they can't know everything, but at that point now they're on notice. And so if it happens a second time, I totally agree with you that some more severe consequences. That's just my thoughts.
If I could respond real quick, I'd say, first off, and the Senator from Charleston mentioned something, and it made me go back to something that Mr. Blake said yesterday. Like, I don't think this should apply to every violation of Title 61. Mr. Blake mentioned that about not having the right license, not having your license up in the right place. That wasn't really my intention. I think it should apply to dram shop situations, right? Because that's much more serious, and I think it warrants a more serious penalty. I maybe the penalty should be much less than 6 months. I'm fine with that. I think there ought to be more. I think we ought to put them on notice before they have a violation, right? I don't want to slap on the wrist. I want it to get their attention, right? The penalty has to mean something. I think if there's a violation, I mean, it is that serious of a problem, right? The penalty has to mean something. We need to deter them on the front end so that they don't ever have a first offense. Now, should that put them out of business? Maybe not. But in this situation, what you've got is somebody being overserved, and then they go out and they hurt somebody because they were overserved. So there's a real consequence to that. I think the penalty has to be one that gets their attention, such that it will deter so that they will be vigilant in training and overseeing their staff in order to prevent that. 6 months may be too much, but I think there ought to be some level of suspension there that they're going to feel it.
And I don't disagree, Senator from Richmond. Also, and I thank Mr. Orr for for pointing this out. This penalty is for that chapter, so it is a violation of the training, not a violation of over serving someone. So I think we've, and that is my fault, because when I read it, I just instantly took it as, oh, that is part of, but this appears to be dealing more with the actual the server training certificate. So if you are falsifying, and quite honestly, if you're falsifying those, I'm happy for you to lose your license for 6 months, because you shouldn't be falsifying those types of documents. So
there is another provision there, and I'm looking for it right now, that deals with, well, this gets into section 5, but 5B, which deals with insurers notifying the department if there's been, no, that's not the right one. There is one where the insured or someone, or the court actually notifies the department of dram shop situations that could lead to penalties. But yeah, I mean, that's what, and maybe I was talking about the wrong one, but that's what I was really trying to get at, is I want to deter the conduct. Yep.
I think that any bar, restaurant
any worth, any value, any operating value to its owners, they're going to be concerned if you just close them for 1 month. I think that's a deterrent right there just to get their attention. And if after that 1 month, they realize the death knell's coming, if the knowing, if you do too many months, you're gonna put them out of business anyway, permanently. So if you want to try to bridge the gap between, okay, maybe not a really bad actor, you do 1 month or 2 months. And that in and of itself, anybody in the business is going to be scared to death if there's people overserve. And then the second one, yeah, let it be the death knell. Because then, by George, they're going to really pay attention to their employees if they weren't already paying attention. So I think we're really all agree that number 2 is the death knell for overserving. And if we want to talk about the other ones, I got opinions on that too. Mm-hmm.
Senator from Berkeley.
Thank you, Mr. Chairman. So I want to go back. I don't think about the server section, but the holding them accountable for over-serving and continuously doing it and stuff like that. Is there a way we can make the cities and towns part of that too? I mean, they should be more familiar with what's going on. I know when I worked for the city of North Charleston, they would remove business license all the time, the clubs and stuff like that. And if we can make them a part of it, that I think builds history, showing, okay, they are an issue. That's the reason why we're going to hold them accountable.
Well, and somewhat to that end, someone sent me an article yesterday in the Charleston Business Journal that Charleston has ran a pilot program with something called IntelliCheck. They ran it at bars, and 100,000 IDs were put through this. You walked into that bar, they scanned it. It found 3,400 fake IDs. So you got to figure, that's a couple of drinks, that's 6,800, 7,500 drinks at a minimum that weren't served to minors due to fake IDs. And that when they ran it through the pilot program, they found that they had I believe it was a 99% accurate. This thing could detect the Chinese fake IDs. It actually worked. There seemed, and Charleston's about to mandate it apparently at every bar and restaurant in Charleston. I am sure there is a cost to this, but I can tell you, if we want to stop underage drinking, mandating this type of technology, which exists, would probably go a long way to do it and would help ensure. If I'm an insurance company, man, that would make a huge difference to me as I'm trying to write your liquor liability policy, that I know that there aren't going to be underage kids in your establishment. You had a 99% accuracy rating. So just another thing to consider as we're going through this process.
Mr. Chair.
Yes, sir. Senator from Richland.
I'm not trying to replace Senator Adams as the law and order senator on this panel, on this committee rather, but I'm just beginning to wonder at what point does this conduct begin to morph into being criminal? As far as it's what the senator from Edgefield said, just wanting to make sure that we are doing all that we can to prevent restaurants and bars from over serving people. I don't know about your experience, Senator Adams, but I know a lot of DUI cases that I either prosecuted, defended, or I presided. Usually the culprit had left a restaurant or a bar. I'd be curious to know what your experience was, in law enforcement, for several years as well. But this desire that we have to bring down the number of DUI, but not just the fatalities, but even DUI related accidents where people are seriously injured, and just DUIs in general. Because it seems like we've tried a lot of things since 2005. The numbers are still high, and I still stand by a pronouncement I made earlier about perhaps ignition interlock devices. That being included for future vehicles that are manufactured. But do we look at, criminal penalties perhaps for some of these bars and restaurants that knowingly overserve individuals, and then that person goes out and gets into a car wreck, injures someone, kills someone, right? Granted, we have the dram shop, this dram shop liability, but that's just civil, right? But should we be thinking about perhaps criminal penalties as well? Because I think if we're able to, if there's more accountability uh, with respect to the bars and restaurants, maybe that they're going to be more cognizant, not just being mindful of civil liability, but probably even doubly cognizant, because there's the risk of maybe criminal charges, and so which should reduce the likelihood of them over serving patrons. So I'm just wondering, is that something that we ought to be looking at, as opposed to putting all our eggs in this box of just, as far as, changing the tort law or what have you, maybe, looking at some criminal penalties on that end.
Yeah. So, so when it comes to DUI, I think that's the reason why we've taken up the DUI side as well in our committees, because we have to start impacting the DUIs in our state. And I think we got that part of it's going to start holding those who choose to drive under the influence accountable. And we have got to get back to that point. Now, holding restaurateurs accountable for something their servers done or a bartender's done, I think that's going to be kind of hard to do, to hold them criminally. They're not there. The owners aren't there, or the managers aren't there all the time. They don't see. I think the best they can do is they train, they mandate, they put their policies in place, they put their systems in place, and then now we hold them accountable, whether it's fines through the cities or through the DOR. I think those are how you hold them accountable, but I think we have to make sure we're getting the right overserved too. We have to make sure that they're, I think they have to be knowingly. I mean, it's hard to get somebody that you serve them 6 tequilas, they're going to be intoxicated in about 30 to 45 minutes. So you have to take care of those people. If you're going to serve that, you better figure out a way. They should not be driving out of there, or they better be living above the establishment or whatever it is. I don't know, but reality is we got to be smart about it, hold them accountable. And if they're constantly serving people or falling off a stool and they let them walk out the door and get into a car, those are the bad apples that are making it bad for every other legitimate restaurant/bar. So that's kind of how I feel about holding the owner or somebody accountable criminally regarding that.
From Charleston.
I think the senator from Berkeley made some good points, and I'm not sure who are you talking about, making the owner criminally liable or the individual who served the drink
It could be the
criminally
individual.
liable?
I guess it would depend on the circumstances, Senator Campson. And I'm not suggesting that is that we should do it. I'm just asking, is that something we ought to begin to look at or consider?
Well,
when I hear that, okay, we've made changes to the DUI law in South Carolina. We've done it multiple times since 2005, yet numbers are still up in terms of fatalities, right? And in a lot of cases, when folks when they drive under the influence, they usually leave a bar, they leave a restaurant, right? And so that's why I'm just asking, are we putting the ladder on the wrong wall when we just say, hey, we're only going to, we want to enhance the penalties for DUIs and maybe not deal with the root cause, which is when someone goes to a restaurant, they go to a bar, and they are served they're served more than they're overserved alcohol, if you will, right? To the point where the person's intoxicated, they leave, get behind the wheel of a car, drive down the street, hit someone, kills them, seriously injures them. I'm just wondering, in that scenario, in addition to punishing the culprit, do we look at some sort of, criminal liability for the bar owner or whoever who works on behalf of the bar? Looking at some criminal liability there as well, in addition to civil liability. And I'm just asking the questions. That's something we want to consider.
I think that would be novel, because you'd be like, the bar owner may not even be at the bar, may not have had any engagement with this individual that they're they have, I mean, you're relying on servers, you know, you're relying on bartenders, you're relying on servers. I'm not even sure there'd be criminal intent. Would there even be criminal intent in the owners for the owner who's not even there? And you are relying on others to execute and apply this law, and it inherently is not done to perfection. It's not done consistently. You're hiring. Sometimes you're hiring temporary pay people, waiters, bartenders, who have been trained by another organization but not yours. And so I think going down that road is, you know, like for on the first offense, I think a big fine, because if you a really big fine, but you can still at least stay in business, and you get a second offense and then you're gone. But you're really, you're relying on some, you know, 20-something-year-old kids that are doing this on a part-time basis, and they're waiters and waitresses, and they're gonna make mistakes, and that's just the nature of the business. And even the most conscientious owner will end up with some of these waiters and bartenders making, not bartenders as much as waiters, but making bad calls and bad decisions. And even if they've had the training, you know, which is really important that we have that training, and it should be mandated. But I just think that's the reality. You know, if every offense there was criminal intent in the mind of the bar owner, for sure, you know, but that's just not the way it really works. And so you got to get their attention. First offense, big, what we were talking about earlier, a really big fine. But I don't think you pull a license for 6 months, because that probably kills the business, you know. And I would do it if the business owner was the one who was engaged in all of these actions and delivering all of these services, but that's just not the nature of the hospitality industry, not the nature of a restaurant, not the nature of a bar. You're relying on 20-something-year-olds that are working for tips, and been trained, but they're gonna make mistakes. And we want to incentivize the owners to be as diligent as they can, and we can do that with the big fines and the training requirement, the big fine, second offense, you lose your license. But that's just the real dynamic that's really at play in these bars and restaurants.
Let's go Senator from Greenville, then we'll go back to Senator from Berkeley.
Thank you. On this, back to the topic of the 6-month suspension, do we determine there's another section in here that applies to Chapter 21 in general?
I'm not sure if we.
Excuse me,
So
Title 61 in general.
The current code has 61-450, which talks about the offenses for unlawful selling of alcohol to people under 21, and it's a $200 fine, right? But I've not been able to find in here that we have that yet. And I thought I'd read it at one point, but I just can't.
Mr. Chairman, if I could.
Yes, sir.
Towards the end of section 2, big section 2, we've got 2A, which is the dram shop stuff. 2B says that in addition to a civil liability for that a violation of the dram shop is ground for revocation or suspension of the permit. And then section C, right below that, is the part where that when if the department receives a evidence that there's been a judgment, which means there's been a trial, right? Which doesn't happen all the time. Most of the time it doesn't. Most of the time there's a settlement. But if there's a trial and there's an adverse judgment, that's pursuant to that provision, then that could be considered by the department in that as well. So I think that's, hopefully that's
and that-
responsive to your question.
It is, and that says department may. So given to what Senator Tedder mentioned, discretion. But I do think if we go back to, I don't want to belabor this, but if we go back to the section, the server training section in 3, if we're just talking about violations of the chapter, the server training chapter, that is a harsh penalty for 6 months, because I mean, I'm just looking through, you have there specific dates and times and when you got to get the license, and of each server has to be trained, and then it lasts for 5 years. So that could just be a technical violation that would lead to a 6-month suspension. So I do think we need to look at that.
Well, this, to that point, this is a different provision too, right? You're talking about the server training.
Yep.
I mean, there does need to be, I mean, like, we also, I think, need to tell the owners, the restaurant, look, we're serious about, you need to have your servers trained, right? So there needs to be some kind of a penalty there to enforce that.
And question, just if in sub 2 on that same section on page 10 of the version I'm looking at, line 31, section 3, chapter 3, for a second offense not related to the first offense. I mean, shouldn't it? I mean, it makes logical sense to me for a second offense related to the first offense. I'm on page 10. Well, yeah, but in that, on page 10. Yeah. Yeah, but that seems like I mean, it could be something totally unrelated. Okay, good. And I'll make a comment on the server training in general. I'm all for it, and I think everybody up here is for it. My question is, I'm hearing that most of the insurers require server training as a condition of writing the policy. So big picture, yes, it helps, but I'm not sure how much it helps. Without it.
But what I'd say is, I can't imagine an insurer writing a policy that doesn't include that requirement. But, from what we heard, especially from Mr. Berger, who apparently does a lot of work in this field, there are lots of the issues that he encounters are because servers have not been adequately trained.
I think there's a difference
Senator
in-
from Berkeley, real fast. He's been patiently waiting.
Yeah, and I just want to get back to the criminal side, but also I about guarantee too, all the restaurants that were here yesterday and talking, I about guarantee that all of them had systems in place, policies in place. They're not your bad actors. But to go back to being able to do some sort of enforcement with them, we're putting a lot on a server, bartender server, to where we can go back, because we don't know what the patron, where they were prior to getting to that establishment. We don't know if they're on prescription medicine. We don't know anything. So one step away from doing a survey, give a survey to them, find out what they did before we can start doing some of this thing. So I think it's just really back down to training, let them know our policies are in place. These are what we do. Utilize the cities and towns, because they know more, because their police get dispatched there all the time with their problems. They know that they're coming there. And I think that would help us move towards that direction of holding those establishments accountable. So.
What, Mr. Chairman, what would local police be enforcing?
So a lot of times they get dispatched there for nuisance, a lot of fights, shootings, noises, things like that. So, and those are usually the ones where the people are over drinking and leaving from, and then the police are constantly going there. So the cities use that to go in and close them down for being a nuisance in the community, and they end up pulling their city license. So I think if we can attach some of that and utilize that, if that's a problem, and I think that becomes they create their own mess, and we can then take their license. So, but that's usually what they get dispatched for.
Yeah, and I was just going to add that I agree with you and Senator Adams that for me, when we talk about starting to criminalize owners, that's probably that's a step a little bit too far, just because, as you stated, you don't know if they popped a pill. I mean, we learned about all this poly drug stuff and the DUI subcommittee, but I mean, they could, pop even prescription medication that could affect them, and they go in and get a drink, and then you got
Or the
bars,
THC drinks now too that are readily available to everybody.
and then you can have people in the back. I mean, so like bars, I mean, like take, for example, take halls. And so like somebody can go get a drink at the back bar, and then you go to the front. I mean, the halls downtown Charleston. I mean, you have restaurants now that where you open a tab here, the tab, you don't have to open a separate tab upstairs. It transfers. And so that, to me, because now you got different, and to your point, you put a lot of stress on the servers, because now you got 2 drinks from Bob in the back bar. I mean, so Sally up front doesn't know you had to, because I don't think that, well, I mean, I don't, they can probably go through in the system and look at the tab, but when they move, they just add in the thing. I don't know if they're going through to say, okay, Mr. Brown had 2 drinks in the back. So that's a slippery slope when we talk about criminalizing. But I agree. I think what will deter them is that hit on that, the first offense, the hefty fine, and or the, hey, was the next time, that suspension. Because any suspension, whether it's 30 days or 4 months, that's going to hurt their bottom line significantly, and that sends a message. And so I think more so that than criminal penalties for those restaurant owners.
Yeah, y'all know better than me. I've never done any criminal law at all, but I'm not even sure there's criminal intent if a bartender or server in a restaurant overserves, and the owner would be the one who would be charged with the crime, but I don't even think there's criminal intent even to constitute a crime really there. But that's the reality of how it works. And that you got to be a great to keep all those servers and bartenders straight and narrow on the straight and narrow is very difficult to do. I mean, it's a difficult task, because it's important to keep that in mind. You're dealing with 20-something-year-old kids that are servers or bartenders often, and there's different personalities and different levels of maturity, and that's tough to make it all. You're gonna have some mishaps there. It's just the nature of the beast. So
Everyone, I think we're going to begin to, we're going to stop. But I do want to say this, we are going to report this out with a favorable report here in a second. If you need to have any amendments that you might be bringing up prepared for Tuesday, just an assumption that there is a meeting on Tuesday. I would assume for those in the crowd who we have asked to work on compromises, and I will repeat, that is the UIM language, occurrence, bad faith, and seatbelts. Y'all have said you're going to work together to try to do something. We ask that you do that. There will be amendments on the floor. I mean, we can't pretend that that's not going to happen. So you have time, but you don't have a month. You have days, maybe weeks, little weeks. So I encourage you to work together, do this. I want to thank every person who testified, especially those who stood side by side or sat side by side and kind of debated each other. I felt that, at least from my perspective, that gave me more insight into how each side viewed an issue, and that give and take was invaluable to me. And I appreciate that, and I appreciate every member and the fact that you all were so active and involved in this process. I think we have one of the goals when I talked with Senator Bass earlier on, we wanted to flesh out this bill and talk about it. And I feel we have done that. So at this point, I am happy, unless someone has any comments, I'm happy to take a motion. We got to put both bills out. It's two different motions. There's a motion for a favorable report on S184 and S244. We have a first and a second. All those in favor say aye. Aye. All opposed? Hearing none. Is there a motion to adjourn?
Absolutely.
We are adjourned. Thank you all.